any such legislative assignment in the name of Rivers State House of Assembly. A three-man panel led by Justice Jimmy Olukayode Bada, while delivering the judgment in the suit, upheld the appeal filed by a factional speaker of the Rivers State House of Assembly, Martin Amaewhule, and 24 others against the speaker, Victor Okojumbo, and 2 others. The court, in its determination of the issue of jurisdiction of a lower court to hear and also grant an exparte order, held that the Federal High Court is exclusively and mandatorily the only court that can hear such matters and not a state high court, citing section 273 of the Constitution. Let me start with you, Jamala. What is your take on this development?
All right. I think let me start by saying the section is section 272 sub 3.
Okay.
Not section 273.
Yeah.
Yes. Yes, what have transpired yesterday, the ruling of the Court of Appeal, is not something strange to law. We have that knowledge from the beginning. I know when the exparte order came on the 10th day of May, the issue so many persons were not discussing were that of jurisdiction, were concentrated on the activities that these persons were prevented from carrying on. Now, the issue of jurisdiction, like the court said, jurisdiction is a foundational thing. In fact, for you to start a building, the foundation is the first thing that you should consider. And the level of the house will also determine the depth of the foundation. So that is what jurisdiction is all about. So the court was right. Section 272, sub 3 of the 1999 Constitution places that jurisdiction squarely on the Federal High Court. And therefore, the State High Court has no business to dabble onto determining whether or not the seat of these legislative members have been vacant. Whether they defected or not is not at the moment what we are discussing. Whether the court is properly clothed with the powers to look into that question. So before you look into that question, you must first assess yourself, appraise yourself whether I have the necessary powers to answer the question, or do I have the necessary intellect? And that is where the jurisdiction comes in. So yes, the Court of Appeal has, to a relative extent, reassured us that there are still there is still sanity in the judiciary. Remember, the judiciary has been, for lately, because of some political rulings and judgment, have been so far been at loggerheads with the masses. And the masses somehow seem to lose what they call it, respect and hope on the judiciary. It used to be the hope of the common man, but that assertion is somehow questioned. But the ruling of yesterday has re-echoed and reaffirmed that position. It is true they were correct in all fours, but the issue as to whether or not they are decamping affected the legality will be a subject for another discussion.
All right, we'll still come to that. Barrister Sims, your takes.
Yes, thank you very much. Please, if you excuse me, I have to frown my face a little bit because of the lights and affecting my eyes.
It's okay, sir.
Yeah, but what I want to say is that, yes, yesterday the Court of Appeal made a decision that we knew was going to happen like that. When this issue started, the House of Assembly issues in Rivers State, we saw where state high courts were delving into matters that affect the legislature, and we also saw them participating in matters that affect defection or non-defection, speakership, or who should not be, as the case may be. And we raised objections. I still have some of the tapes, maybe on radio and television, to say that the courts, the lower courts, the River State High Courts, do not have such jurisdiction to entertain such matters. And I thank God that we have been vindicated. Two is that I remember also that Justice Chiwendu Wogu of the Rivers State High Court also declined jurisdiction when matters of this nature were brought before his court. He said, I lacked jurisdiction to entertain. People said, no, why should you say that? This is a matter he has been brought, he has compromised. But I said it was sound law that the judge has given, and he's standing on that particular pedestal. That on this issue that pertains to vacant seats or etc., it is not an exclusive for the State High Court. It's for the Federal High Court. And he has been vindicated. Likewise, Justice Okobule, I'm mentioning their names so that Nigerians will begin to know and look at them that these are people with some modicum of integrity. Judges, when they say judges or judiciary is a problem, there are judges who have refrained, from, dabbling into this. Then the third one that worries me is this. We were taught elementarily in school that if a client brings a matter to you and you want to go to court for litigation, there are issues you have to first of all look at. Who are the parties involved? Is there any cause of action? Jurisdiction, of course, to entertain, those, if you want to maybe litigate on it, and some other issues that you have to consider before you now file your action. The question I'm asking is that, are you saying that the judges were not aware that they lack jurisdiction and would have, washed their hands off like Chiwedu Wogu and Okobole Basam did in this? Justice Wali was not aware. Okay, what about the lawyers, the senior advocates, or whoever they are, that filed this particular matter without taking into condition these preconditions, that are needed for them to file such matters? I don't know why they did that, but at the end of the day, you see what has happened now. So I'm very happy that the Court of Appeal has, come out boldly to say that if you lack jurisdiction, you cannot even entertain or touch a particular matter with a very long pole. And if you now ascribe jurisdiction to yourself where you lack jurisdiction, it means that whatever you have conducted, no matter how beautifully conducted your proceedings in court are, it goes to nothingness. It becomes null and void. So yesterday, Justice Wali and his court or whatever and the others are null and void. So they couldn't touch that matter. So on the matter finally on this, because a lot of people are giving interpretations on social media, but I don't want to participate in the social media, whatever as the case may be. There are reasons people have to celebrate. Where, because, like I said, Jeremy Bentham, in his principle of open justice said, publicity is part of justice. That if you deliver a judgment or a ruling, people do not maybe jubilate or people do not complain, as the case may be, that you have not done justice. So when people begin to say, no, this is in our favor, this is not in our favor, whatever the case may be, it means that something, very laudable was done that yesterday. So I don't blame those who are giving different interpretations, but lawyers should be very, very careful not to mislead the public, as the case may be. Finally on this, the rights accruing from that particular matter, as the case may be right now, is something that is very clear. They are not saying they should go back and maybe Amaehwule should become the speaker, as the case may be, or maybe replace Jumbo, or they have removed Jumbo. So what this has cost, in Rivers State now is that we now have two parallel, levels again. Jumbo faction, Amaehwule faction. Because one of the reasons why they went to court to stop, why Jumbo went to court was to stop the Amaehwule faction from parading themselves, as members of the House of Assembly of the state having defected. So it means that they have to go back to status quo, before they went to court, which means that you are going to be seeing meetings being held, by the, or maybe proceedings being held by the Amaehwule faction, and giving bills like they did before, as the case may be. And also they can also hold their whatever at the official quarters, the House of Assembly quarters, without interference, as the case may be, until and unless, another court says otherwise. And mind you, finally, Okojumbo can still go to court, to the appeal court. His faction can go to appeal court to, better arrest or vacate this particular court of appeal order, or they jettison it, file a proper action before the Federal High Court, as the case may be, or they leave it and let the Federal High Court matter before Motosho be decided on other ones. as the case may be. That is my take on this.
He raised a point that I would like us to look into, and that is mentioning the issue of that has to do with my Lord Honorable Justice Amaehwule. Now, Amaehwule, when the matter of this fight by the, in quote, Rivers elders was brought before him, the matter was slated for mention, further mention, and proof of service. The ruling he gave that day was dismissing the suit for want of jurisdiction. We are not saying that, I'm not arguing that he, looking at the circumstances, properly clothed with jurisdiction, but looking at procedural. Was it proper on that said day for him to have taken that action? To me, in my own limited knowledge of the law for now, and procedure of the law, I think is wrong. Because where a court finds out that from the processes before him, he lacked jurisdiction, like the Court of Appeal reiterated yesterday, jurisdiction of the court is mostly seen from the processes filed by the plaintiff himself or the claimant in the circumstances, that is to say the writ of summons or any of the originating motions. Now, where a court so moved to raise that question as to jurisdiction, it calls for addresses from the respective councils representing parties. That wasn't done by, that procedure wasn't followed by Amaehwule. That is the cross of our own argument with respect to his declaration. It is when you ask the court, the lawyers, please, from the processes I found before me in this court, do you think I have jurisdiction? Address me on that. Then the parties will either argue orally or file their written addresses. Then the court can now make a ruling. So it's different. That of my Lord, the Honorable Justice Okobole Basan, yes, he declined jurisdiction very correctly. And so the other ones given us to determine the merit or otherwise of the case were all bitter. And in the circumstances were not even enforceable. And so I agree, yes, that it was purely correct, procedural and law, talking about the law. But for that of Justice Amaehwule is wrong. But and the third day, looking at whether a judge could err. Judges do err in law. They err in law. Whether a judge may inadvertently not be aware that he lacks jurisdiction in entertaining. I'm not saying though there are some who do not do so, properly knowing where that what we are doing is for a particular mischief, right? But there are those who, yes, they may have the knowledge as by the time they are taking that delivery that maybe the understanding of the law is that I have jurisdiction. Some were quoting Section 272 because it read with Section 251. And if you go to Section 251, talking about the exclusive and residuary list, things that the state high court can, state assembly can dabble into, state, federal, national assembly can dabble into. So if you read it too, I have this conversation with lawyers, even in the office, some were holding the view that the state high court, if you read with Section 251, had that jurisdiction, and I said no, shall. The specific mention of the federal high court is to deliberate exclusion of all other courts in the country. So I believe we should try to separate them. Amaehwule was right in his thinking of the law, was wrong in the procedural of arriving at that decision.
Right.
Well, I don't know if let me just, you see, I don't like, stretching legal limits and whatever we are discussing if we are periscoping an issue. I'm very happy that he said, he was right, under the, on the basis of the law, but procedurally, which we call technicalities, he was wrong. But as the case may be, let me say with due respect, assuming so, because you see, the bastion of hope or last hope for the common man is the judiciary. Therefore, if an issue is before you, and you go through the processes filed before you, the court can only so sumo to come out and say, look, address me on jurisdiction. I feel I lack jurisdiction on this matter. Can you address me?
But that's the point I said.
That's what I'm saying. He has that option, but he did not avail the parties in this particular suit that was, discountenance yesterday by the Court of Appeal of these options that were left to him. He went ahead to enter into the arena, you understand, and gave a decision, an exparte decision. Let me give you for an example what the Court of Appeal said. I have it, I had to serially, copy it out so that we understand. We know that I had to copy it out. He said, the Court of Appeal, now speaking, said, the court lacks jurisdiction and that there must be an existence of real urgency and not self-imposed or induced urgency in granting ex parte order. That is, assuming they even have assuming the lower court had jurisdiction, as the case may be, that for you to even grant an ex parte order, these are what the ratio that the particular court now gave. That for you to, assuming you even had jurisdiction to do this, you would have looked at it. The urgent nature, is there an imminent urgency that is involved here? The court said there was none. And you lack jurisdiction. These are things I feel the judge. I'm not trying to poo-poo the judge. I know we make mistakes. Judges make mistakes. Even lawyers, we do make mistakes too. That's why we call it legal opinion. My opinion might be different from yours, but it does not mean that we are not lawyers. We are lawyers, as the case may be. But we are saying he should have, as an experienced judge and a hallowed one for that matter, I believe he should have profiled all these things and given them ambit to operate. Otherwise, it will not go to where people normally say that most judges in Nigeria today make their political view, make their legal view, from their political view. That is most judges. That is, I was so scared when I read an article on this written by a highly respected scholar, an erudite scholar, this former NHRC man, Odinkalu. He said most judges in Nigeria, they put their political views on their legal view, which is very wrong. That is, it's a sad commentary. And I think I commend the Court of Appeal, and most judges should take note from this and begin to be very upright when they are doing things of this nature.